Welcome to your custom deep dive. Today we have a really fascinating one.
Yeah, we're unpacking a brand new legal thesis out of Mexico.
Right. Digital Record 231472 to be precise.
It just hit the Federal Judicial Weekly on November 14th, 2025.
And our mission today is to break down this crucial Supreme Court ruling.
Right, because it essentially builds a fortress around workers' pensions.
It stops administrative agencies from stepping in and modifying them after a court has already made a final decision.
Which is a huge deal. It tackles that classic friction between, administrative bureaucracy and judicial finality.
It really does. And it all traces back to Article 123 of the Constitution.
Yeah, the guaranteed safety net for workplace accidents or illnesses.
So if you can't return to work, you apply for a permanent, partial, or total pension through the Mexican Social Security Institute or the IMSS.
Exactly.
Okay, let's unpack this. Say you go through that initial evaluation and you strongly disagree with the pension the IMSS hands down.
Well, you basically face a fork in the road. You have two choices to fight it.
Option one is keeping it in-house, right?
Right. You file an administrative challenge within the IMSS itself.
Option two.
Option two is you step outside the agency completely and take the case to the federal labor courts.
And going to the labor courts is where the first, second, and third collegiate tribunals of the Eighth Circuit completely split.
They were clashing hard over Article 61 of the Social Security law.
Just to give you context, Article 61 normally allows the IMSS to adjust or modify a pension if your medical condition changes down the line.
Right, if you get better or worse. But the big question became, can the IMSS still pull out Article 61 to modify a pension if a federal court was the one who awarded it in the first place?
Not just an internal IMSS decision, but a federal court order.
Yes. What's fascinating here is how the regional plenum finally stepped in to resolve this tug of war.
They drew a very hard line, didn't they?
They really did. They ruled that Article 61 is strictly an internal administrative mechanism.
Meaning it belongs entirely inside the IMSS structure.
So if a worker bypasses that internal appeal and successfully claims their pension before a labor court,
then Article 61 is completely inapplicable.
you got it. It's off the table.
So what does this all mean?
If we connect this to the bigger picture, it really comes down to protecting legal certainty.
It's almost like a referee calling a touchdown, but the opposing team's coach pulls out their own personal rule book to overrule the ref.
That is a perfect analogy. You simply cannot have an administrative agency overriding a federal judge.
Because once a labor judge hears the evidence and issues a final sentence recognizing a specific pension,
The IMSS cannot retroactively use its own internal rule to restrict or change that outcome.
because doing so would completely destroy the principle of a settled case, or res judicata.
Right, meaning once a judge bangs the gavel, the case is closed.
An agency can't just move the goalpost retroactively.
Otherwise, you'd never actually know if your case was resolved.
That's the crux of it. Allowing an agency to alter a finalized judicial ruling makes a mockery of the court's authority.
Which is why this ruling, making this jurisdictional boundary absolute, became mandatory across the board on November 18th, 2025.
The judicial system is really planting its flag here.
Ensuring that once a court grants you a workplace pension, an administrative agency can't just dig into its own internal rule book to undo it.
It's a massive win for legal certainty. But before we wrap up, here's a question for you to ponder today.
This is a big one.
If administrative agencies were actually allowed to quietly modify finalized court decisions, what would happen to the foundational concept of justice?
Right? Everything would unravel.
And looking beyond this specific case, how often might internal agency rules be silently conflicting with judicial authority in other areas of your own life?
Definitely something to think about.
Thanks for joining us on this deep dive.